Welcome to this month's episode of RTO Insights, brought to you by the Association of Progressive Rental Organizations, the nation's rent-owned trade association, and sponsored by Rent Direct, a division of Nationwide, the country's largest retail buying group. My name is Ed Wynn III. I'm the General Counsel for the Trade Association. I want to talk today a little bit about the legal history of rent-own. I am a lawyer, so you'll have to forgive me if I want to talk about the law. In the 1970s, when the industry was beginning to grow and grow rapidly, there were no rent-to-own statutes anywhere in the country. There was, of course, the Federal Truth in Lending Act that regulated credit transactions, and there were in the states Retail Installment Sales Acts that also regulated credit sales with usury limits and finance charge limits. The industry began to suffer lawsuits brought by legal aid lawyers under the Truth in Lending Act. The Truth in Lending Act had been a bludgeon used against banks in the 70s to exact millions of dollars for technical violations. Legal aid lawyers thought that they could take those same kinds of lawsuits and apply those to the rent-own industry. The industry won a lot of those lawsuits, but they didn't win them all. As a result, the industry banded together in 1980 and formed the trade association APRO as a means of defending itself and as a means of getting some safe harbor legislation either at the federal level or at the state level in order to protect what had become a very valuable industry. So no sooner had APRO been created in 1980 than representatives from the trade association began to go to Washington, D.C. to see about getting federal legislation passed. At about that same time, there was a move afoot in Washington, D.C. to simplify the Truth in Lending Act, which had originally been enacted in 1968. As a part of that investigation, the Federal Reserve Board staff, lawyers, and others made contact with the Trade Association and wanted to learn more about how rent-to-own worked, to see whether and if and how to regulate rent-to-own at the federal level. We had numerous conversations with the Federal Reserve Board staff lawyers and set up meetings for them to go and have store visits in Maryland with some of the original APRO members. What came out of those discussions and store visits by the Federal Reserve Board lawyers was language in new Regulation Z, which is the regulation that governs the Truth in Lending Act and is promulgated by the Federal Reserve Board, was, for the rent-to-own industry, magical language that declared rent-to-own transactions are not to be considered credit sales under federal law. Those words, which became law in 1983, really took the wind out of legal aid lawyers' sails, and they quit suing rent-to-own companies as a result. While the industry had great success in working with the Federal Reserve Board and getting appropriate language in Regulation Z, it came fairly close to getting the Congress to enact favorable rent-own legislation. As a part of the Bank Simplification Act of 1982, there was language in that bill that passed the Senate 93-0 that protected the rent-own industry. Unfortunately, that bill died in the House in the closing hours of 1983. After that, the industry kept trying to get legislation passed in Washington, D.C., but not successfully, and quickly moved to working in the states. In December of 1983, the very first rent-to-own statute was passed in Michigan, became effective in 1984, and also in that year, the states Texas, Alabama, and South Carolina also enacted rental purchase legislation. What followed over the next 20 years were 47 states that enacted favorable rent-to-own legislation. Sometimes the industry sponsored those bills, sometimes the industry was in a defensive posture and fighting back against legal aid lawyers and other consumer advocates. In Wisconsin, there was bad case law early on in the early 80s, and there has never been rent-to-own legislation enacted in Wisconsin. Similarly, there has never been rent-to-own legislation enacted in New Jersey, and the New Jersey Supreme Court has decreed lately that rent-to-own transactions are credit sales for all purposes in that state. Minnesota actually enacted a rent-to-own statute, but then the Minnesota Supreme Court declared that rent-to-own transactions are also to be construed as credit sales in that state, and no one can do business under those two statutes at the same time, so there really is no rent-to-own industry in Minnesota. In North Carolina, the legislature actually declared that a pure rent-to-own transaction was a credit sale, but then they went on to define nominal consideration so that if you have a balloon purchase option at the end of your transaction equal to more than 10% of the cash price, then your transaction is not a credit sale and is otherwise unregulated in that state. So that if you've got a $500 TV, you got to have a final payment in your rent-to-own transaction of $55, and then your transaction is unregulated in North Carolina. As time has gone on, from 1983, when the first law was enacted, to the late 1990s, when the last statutes were enacted, the statutes little by little get tougher and tougher. California has one of the toughest regulatory schemes in the country, and likewise New York, which recently amended its rent-to-own statute and put in price caps on cash prices and rent-to-own prices. Once we got these rent-to-own statutes enacted at the state level, we in the industry were originally fearful of ever going back to those states to try to fix problems in these laws. We were worried about opening up the legislation and being attacked in the legislature. However, history has proven that that attitude was wrong. Indiana has, for example, amended its statute 13 times. Texas has amended its statute 4 times, and all of those amendments are favorable to the industry. The industry has had a safe legal harbor in these 47 states really for the last 20 plus years. I do not think that's going to change in my lifetime. Even so, there are consumer advocates, there are legal aid lawyers, and there are plaintiffs' lawyers who do not like this business, mainly because they do not understand it, and they are ever alert for opportunities to oppose the industry and to do damage to it when they can, where they can. Those kinds of changes in the law might come in the tax law, in the employment law, or in tighter regulations of the rent-to-own transaction itself. Rent-to-own is a good business, it's a valuable business, it's providing goods and services to millions of Americans each year, the necessities of modern 21st century life, and it's deserving of your support and the protection of the laws that we have worked hard to get enacted. I want you to remember how valuable your business is to you, to your families, to your customers. I want you to learn who your friends are in politics, and I want you to vote for them every chance you get. And until the next episode of Rent-to-Own Insights, treat your customers like royalty. They deserve it. I'm Edwin III.